Okay, I think we're ready to go. Hello, everyone. My name is Stephanie Donovan, and I am an employee benefits consultant here at Walsh Duffield. I want to thank you for joining today's webinar, Legislative Updates, presented by Frank Kerbin of the Business Council of New York State. So this is our last summer school webinar, so we hope you've enjoyed our lineup of topics these past 2 months and have learned a few things along the way. Before I introduce Frank, I'd like to cover a few housekeeping items. Today's webinar is being recorded. We will share the recording and slides after the event. This presentation is approved for 1 SHRM professional development credit and 1 HR recertification credit hour through HRCI. We will email the code needed for these credits to live attendees after the webinar. We invite you to comment and question. Please use the Q&A box on your screen. If you think of a question at any point, just type it in there and we will hold it for the discussion portion at the end of the event. And with that, I'm happy to introduce today's presenter. Frank Kerbin is the director of the Center for Human Resources at the Business Council of New York State. When he isn't presenting at our seminars and webinars, Frank spends much of his time in Albany, lobbying for businesses and trying to understand the ins and outs of the latest New York State legislation. Today, Frank will be discussing some of the latest updates impacting employers in New York State, particularly in employee leave laws, compliance, and the impact of legalized cannabis. At this time, I'm going to hand the floor over to Frank, who is going to start today's presentation. Frank, it's all yours.
Hey, thank you, Stephanie. Thanks, everyone, for having me back again at your program. I always enjoy my annual trips out to Buffalo to talk about HR updates, and I hope we all get to do it in person again soon sometime. And thanks, Walsh Duffield, for having me. I appreciate it. We're going to talk about what's going on. Anything going on in human resources? Did I miss something? We've had quite a time in the last 18 months or so. You probably heard me say this before, but at one point when paid family leave was passed many years ago, I said, we're living in the golden age of human resources. There's never been a better time to work in HR. That was kind of a little sarcastic to some degree. And boy, was I, though we look back now and those were the good old days, right? What we've done and what we've accomplished in the last 18 months has been pretty amazing. I tip my hat to all the HR professionals that are out there and the things you've done keeping your employees safe. All the statistics show that transmission of the virus didn't happen in the workplace. You've been great at keeping your employees safe and complying with the myriad of laws we've all had to do in the last 18 months. Unfortunately, or fortunately, unfortunately, we live in New York State, so being an HR professional in New York State is never more challenging than it is this time at this place. I'm sure you're all aware of that we live in certain challenging times, and it doesn't look like it's going to get any easier. So let's talk about what's happened in the last few months and what I think is going to happen in the next few months. As always, I have my disclaimer, I'm not an attorney. I'm an HR professional who's been doing this for 35 plus years now. And so I approach it from that perspective. I'm part of the government affairs team at the Business Council, which is the largest in-house lobbying organization in Albany. We are the go-to organization for legislators, for the regulators, for the Department of Labor, for agencies. And I advocate, I'm a lobbyist on behalf of businesses in HR and labor issues and workers' compensation. So we have the advantage of sort of being the people that the legislatures, the governor's office, and the regulators come to when they have questions or they want to run things by us before they do it. They look for our input. Whether they follow it or not is always a different question. But at least we fill that role here in Albany. So let's talk briefly about COVID, right? We have to. New York's been reopened. All the New York Forward industry guidelines that we have been following for the past few months were rescinded on May 19th, as you remember. There are a few in place still regarding large-scale indoor events, pre-K through 12 schools, public transit, state fairs, things like that have rules in place. But unless you're covered by one of those that are still active, we are all subject now to essentially the CDC guidance. And that guidance states now that unvaccinated individuals should continue to wear masks. Unvaccinated individuals should wear a mask when indoors in an area of substantial or high transmission of the virus. I look at the CDC site every day, and it appears to me that every county in New York State is now an area of substantial or high transmission. So again, CDC guidance is just that, it's guidance. There's no penalty for not doing it, no explicit penalty for not following the CDC. OSHA on August 13th issued some guidance saying, they updated their guidance saying that we're going to follow the CDC. So now we have two major government agencies that impact employers, the CDC and OSHA, saying that unvaccinated and vaccinated individuals should wear masks indoors. You don't have to. However, if, Lord forbid, an individual was not wearing a mask indoors in your workplace, contracted the virus, in worst case scenario, passed away, I'm sure there would be a claim of liability that you ignored the advice of two major government agencies, and that led to the death of their loved one. That would be outside of workers' compensation. We could be talking about a liability issue. So my general advice is let's follow the CDC and OSHA and require all our employees to wear masks indoors. What about the HERO Act? I say, hang on, we're going to talk about that in detail in a second. Also, as we speak, Governor Hochul is having a press event regarding the Delta variant and COVID. I'm watching on my iPad. If something interesting pops up, I'll let you know. But it's entirely possible that we could have a HERO Act designation happen in the near future. So stand by for information on that. And we're going to talk more about the HERO Act later on in this program as well. Some COVID stuff just to cover. The federal, we all remember the FFCRA that provided leave time for employees impacted by COVID, paid leave for employees impacted by COVID. It was extended through the American Rescue Plan, though on a voluntary basis. This is all winding down, right? The leave requirement and the tax credits, if you were participating in those, end on September 30th. The extended unemployment benefits, the extra $300 that people were getting for being on unemployment, will end on September 6th, so that is imminent. One of the interesting things is that the federal government said that COVID money given to the states, if you remember, New York State got a little more than $12 billion in COVID money. Money given to the states could be used to extend that $300 extra payment. There's been no indication yet that New York State or the New York State Department of Labor intends to do that. I think New York State has spent or committed to spend that $12 billion on other budget items. So there won't be an extension of the $300 extra payment in New York State as of today. Again, Congress could come back and act and extend all these provisions. The COBRA subsidy, if you remember, provided free COBRA coverage for formerly employed individuals through the end of September. That is ending then. No indication yet that that's going to be extended. A note about New York State's COVID paid sick leave. There is no expiration date on that. So that goes forever. And I have some slides on some of these, and we're going to talk in a little more detail. But it's important to know that New York State COVID paid sick leave is still with us. So if you're under 100 employees, you know the drill, right? You had to pay the first 5 days if someone was quarantined by a public health official, and the rest was through the PFL carrier. If you have more than 100 employees, you paid all 14 days of up to 14 days of an absence related to COVID. New York State vaccine leave expires at the end of next year, 2022. So we have to provide up to 4 hours of vaccines for each of 2 shots to a maximum of 8 hours to employees. We don't know now about the booster requirement. If there's a booster that is approved, it hasn't been approved yet, but if it is approved for use and employers mandate that, do they have to pay for the vaccine for that? According to the statute, no. The statute says 2 absences up to 4 hours each, up to a total of 8 hours. We'll see if the Department of Labor puts out some guidance on that when and if boosters become available. New York State's paid sick leave law, we've all been working with that. This is the plain old regular paid sick leave law that was foisted upon us last year in the middle of the COVID pandemic. As you know, employees are eligible to use that for vaccine side effects and some other COVID related areas. Essentially, we're not going to get into detail about questioning employees for the reasons for using this paid sick leave, but they can use it for COVID related reasons. And paid PFL, if you remember, the Workers' Compensation Board put out an emergency rule saying that diagnosis by a healthcare professional of a positive COVID test would qualify for PFL. That was an emergency rule that has expired. So it is no longer a serious health condition as defined under the paid family leave law, right? The regular seasonal flu is not a serious health condition that someone could use PFL to care for a family member. Now a diagnosis of COVID is also not a serious health condition. That expired. I'm not aware of any rulemaking that are proposing to extend that. I don't think that'll come back. Just a couple notes on the things I just touched on, the COBRA subsidy. If you're not aware, if you haven't caught up on this, the feds will pay the COBRA premiums. You pay them, the Fed will reimburse you for 6 months from April 1st through September 30th of this year for anyone who was COBRA eligible and who declined it, even for those who were terminated and declined it prior to April 1st. We had a notification requirement that we had to go back and notify those people they could be eligible. Talk to your COBRA administrator, or if you have people who might have fallen in this category, maybe give me a call and we can talk about what you can do at this late date. And again, this money is reimbursed to you through tax credits through the federal government as part of the American Rescue Plan. A note on the New York State COVID paid sick leave. As I mentioned, there's no expiration date on that. Initially, it was clear that this leave could only be used by individuals who were quarantined by a public health official and could not come to work. On January 29th, the Commissioner of Labor greatly expanded this. We think she did this extra legally. I don't think it's legal what she did, but someone will have to sue the Department of Labor, and it can't be the Business Council. So someone will have to do that. But what's interesting about it is it gave some medical advice in the Department of Labor, the Commissioner of Labor's guidance document. So I'm going to read just a couple of highlighted things here. An employee, first bullet, an employee who returns to work following a period of mandatory quarantine does not need to be tested before returning to work. A lot of employers had a system in place where, all right, you've been quarantined, I don't want you back in the office till you get a negative test. Well, the problem is that people who test positive for COVID have sometimes been testing positive for a long time, up to 90 days. And if you're going to have that rule in place, there's going to be a cost to you for doing that. We'll see in a second. If someone does test positive, they must not report to work. So if you're mandating this test and they test positive, you cannot let them come to work. But if you don't know, you can let them come back to work. Now, our first thought was this seems counterintuitive to stopping the spread of the virus. The commissioner really didn't care. And when I say commissioner, I read Governor Cuomo. He imposed this through the commissioner. And then the second bullet, again, after the end of such quarantine or isolation period, must not report to work if you test positive. Please note that an employee is not recommended to be tested to discontinue isolation or quarantine. So the department is recommending you don't test them. Up above, it says you do not need to. Here, we're saying we recommend you don't. The gist of these paragraph 2 and 3 here is that an individual could qualify for New York State's COVID paid sick leave up to 3 times, but only if the last 2 times are the result of a positive COVID test. So Frank, I'm making up a story here. Frank was out last December because I was quarantined by the health department because I was exposed to someone who was COVID positive. I never tested positive. I would have been eligible for no COVID paid sick leave. Now, Frank tests positive for COVID-19. I'm eligible for COVID paid sick leave. If you require a negative test to return to work, I test positive again, I'm required for a third batch of paid sick leave. That means if you have less than 100 employees, you're going to pay me 15 days before PFL picks up the rest. If you have more than 100 employees, you're going to pay me 14 days times 3, 42 days of paid sick leave. Even more concerning is the final bullet in the commissioner's letter. And it says, if an employer mandates that an employee who is not subject to quarantine stay home, the employer shall continue to pay the employee. So this was a huge leap. This is clearly not in the statute, but what the Department of Labor says is if an employer is keeping them home, we have to pay them, quarantined or not. So we're seeing a lot of this now. I'm an unvaccinated employee. I was at a party on Friday. I just found out today that one of the people there tested positive. They sent me a text. What do? If we keep them home, we have to pay them, right? So New York State COVID sick leave has been broadly expanded to cover all employers bearing the burden, bearing the cost of replacing income for individuals who we keep away from the workplace in order to keep them safe. Again, we'll take lots of questions on this at the end if you have questions. One word about New York State's regular paid sick leave and collective bargaining agreements. We have an issue here. Again, this is regular paid sick leave, not COVID paid sick leave. But in the law, it says that any collective bargaining agreements entered into prior to 9/30/20, after 9/30/20, have to provide a comparable benefit. It goes down here that says that it can even be a different benefit from what the New York State paid sick leave is, as long as you specifically acknowledge the provisions of this section. So the question was, I had a collective bargaining in place before September 30th that didn't meet the qualifications of the paid sick leave law, didn't meet the accrual, carryover, or use requirements of the new paid sick leave law. Do I have to open my collective bargaining agreement to renegotiate those things? Clearly, any contracts entered into after the 30th have to acknowledge the new law. The Department of Labor, the governor's office said, no, if you have a collective bargaining agreement in place, you do not need to reopen that for the purposes of changing the law. However, the Attorney General's office, who also has enforcement ability here, said, yes, you do have to open your collective bargaining agreement. So which is it? Don't know. These two branches of the government do not get along, the Attorney General and the governor, as you know. I don't know if that'll change this week with our new governor or not, but neither one is giving in on this. So if you have a collective bargaining agreement, my advice to you is contact your attorney to see if it needs to be reopened or not based on his advice. So what else is going on in Albany? It's been busy. There's been a lot of activity. This is a picture of the Corning Tower in New York, in Albany, the tallest building in Albany. Forever it said New York Tough, and some enterprising state employee went through and lowered some mini blinds so that it said New York Touch. The governor Cuomo did not care for that. He now has mini blinds zip tied into place in the Corning Tower, though this is gone now that we have a new governor. But that's how sensitive it's been around Albany and controversial. I know if you live outside the Albany bubble, it's not always as big a deal, but inside Albany, there's been a lot of turmoil regarding Governor Cuomo and his resignation. So to summarize what we have in Albany now, we have one party rule. Democrats control all statewide elected offices. They control the New York State Assembly by a veto-proof majority. They've always had that. It's 100 to 50, let's say, in the Assembly. They now have a veto-proof majority in the Senate, where the Democrats have enough to override any veto of the governor. They haven't had that in, I think, 60 years was the last calculation I heard. The governor was weakened this year because of the investigations, the threat of impeachment, his eventual resignation. Impeachment took a lot of the air out of the room in Albany this year, which is sometimes good for legislation because fewer bad things get passed, right, if they're distracted with something like that. We now have Governor Hochul from your own Erie County, who I think will be a breath of fresh air in some regards, though we're waiting to see how this pans out. She clearly wants to be governor again. And to do that, she may have to, she certainly is going to have to appeal to the more progressive wing of the Democratic Party based in New York City, right? You could win 55 counties in New York State and still not win the governor election because the other 7 counties are the ones that count downstate. We passed the biggest budget in New York State history, bigger than Florida and Texas combined. Each of those states has a larger population than New York State, but our budget dwarfs them even when you put those two together. So New York is spending its COVID money fast and furious. The Capitol was closed for the legislative session this year, so we had limited ability to reach legislators in a traditional way. We did a lot of Zoom calls, a lot of outreach, but as you know, if you don't want to take a Zoom call, you don't have to, right? As opposed to when we show up on their doorstep and impose ourselves upon them. 14,800 bills introduced in the last legislative session. For context, the US Congress introduces about 3,000 bills a year. New York State introduced 14,800. 892 bills were passed both houses, 650 in the last 10 days of the session, in the last the middle week of June, between June 10th and June 17th, 650 bills. I follow HR and labor and workers' comp bills. There were 368 of those. So this legislature, with its new veto-proof majority and its supermajorities, was still very active in pushing an agenda that one would typically say is not always pro-business, right? And so let's touch on a couple of what those major areas were. Significantly, we had the Marijuana Regulation and Taxation Act passed. And yes, New York State spells marijuana with an H. That's why I like to put it in the heading so people know it wasn't me that did that. It's how the state signs it. I refer to it as cannabis because it contains more scientifically accurate description. Signed March 31st, so it wasn't part of the New York State budget process. This is a bill the legislature passed and the governor signed on their own. It immediately legalized recreational use and possession of marijuana by adults over age 21 up to 3 ounces. So wherever it's legal to smoke, it is now legal to smoke marijuana in New York State. It's illegal to purchase in New York State still. In New York State, there will be a cannabis control board that had hoped to have the retail market for cannabis up and running by April of 2022. It now appears that will be impossible. We're looking more towards the end of 2022. But if you live someplace where a border state has legalized cannabis, like Albany is only 20 miles from Massachusetts, a short drive to Massachusetts to purchase cannabis legally. It's illegal to bring over the border, but no one's checking at the border. It is then legal to possess in New York State. It amended the Compassionate Care Act. That's the medical marijuana law that we've had around since 2014. Allows those with prescription to smoke marijuana. Before, you couldn't smoke marijuana if you were using cannabis for health reasons. It had to be through oils or some other way to ingest it. Smoking was not permitted. It is now permissible to smoke marijuana under the Compassionate Care Act. It expands the reasons for use. If you remember, under medical marijuana, it was always every disease that wanted to be included on the list was always a big deal. The legislature would have to amend the law to allow that disease. PTSD was a big one that was added. That went through a lot of rigmarole in the legislature to get that passed. Now it says essentially for any reason the physician thinks it could benefit from the use of cannabis. So we're going to see certainly more individuals be using cannabis under the Compassionate Care Act. So it's more likely than ever that you're going to have an employee approach you and say, I need an accommodation. What's your accommodation? Well, I need to use cannabis to alleviate chronic pain, PTSD, one of these other diseases. My physician says I need to use it at 8 in the morning to get the benefits for each day. So I need to change my work shift from 8 to 5 to noon to 7, right? Individuals are going to come to you with requests for accommodation like that, and you're going to have to consider that. As you know, individuals who use cannabis under the Compassionate Care Act are considered disabled under New York state law, so we have to provide a reasonable accommodation. So be aware of that, watch for the impact of that, because you're going to see more people use it in and around the workplace. Again, the CCA doesn't allow them to use it at work, doesn't allow them to have it possession on them, but there are going to be people who are going to insist they need to use it first thing in the morning or at a time that makes it inconvenient for you. That might result in them being impaired when they come to work. As I mentioned, the Cannabis Control Board, watch that. There's actually a website up that you can go to get information. There's really nothing there now. Governor Cuomo failed to appoint his nominees to the Cannabis Control Board in the time he had from March 31st until the time he resigned. So it's kind of in limbo, and there's going to be some significant delays. Remember that cannabis is still illegal under federal law. I know the Biden administration is looking to change that, but there are many federal laws that regulate and restrict the use of cannabis. It's part of the Controlled Substances Act. It's still a tier 1 drug that, according to the federal government, has no medicinal value at all and is highly addictive. The Controlled Substance Act doesn't talk about employment at all. It doesn't talk about testing or anything. There's the Drug-Free Workplace Act. If you're an organization that is subject to that, if you receive a federal grant or you're a federal contractor, you may be subject to the Drug-Free Workplace Act of 1988. And you're familiar with the requirements of that, right? That you have to have a plan in place, that you have to take action if someone tests positive for marijuana, things like that. And then a whole list of other laws. And there's more than what I have here. Federal Motor Carrier Safety Administration, if you employ drivers who are subject to DOT regulations, nothing has changed by legalizing marijuana in New York State. In fact, DOT has put out a specific statement saying that the legalization in these states has no impact on the requirements put upon drivers under the FMCSA or DOT regulations. So if you're covered by one of these laws, remember these are still in place and you're still subject to comply with those laws. Just an example, the Drug-Free Workplace Act, I know a lot of people are subject to that, some not-for-profits who receive grants. As you know, there's things you have to do. You have to prepare and distribute a formal policy, maintain a good faith effort to comply with this. You must notify, an employee must notify the employer within 5 calendar days of a conviction related to a drug violation. That's still in place. You have to notify the federal contracting agency of any covered violation and take direct action against an employee convicted of a workplace drug violation. But that's it. You don't have to have a testing system in place. You don't have to have routine testing. You just have to take these specific actions if there's a conviction related to violation of the Drug-Free Workplace Act, if you're subject to that. It's a good idea though to let employees know that impairment in the workplace is prohibited, right? We can't have employees coming to work impaired by alcohol, by misuse of prescription drugs, and certainly by cannabis. We have an obligation, every employer does, is covered by OSHA, are required to provide a workplace free from recognized hazards that are causing or likely to cause death or serious injury. So it's important to remember that that's always our obligation. So we should always prohibit impairment in the workplace. So what do we have? When the law was first proposed, we had a lot of problems with the law, and we did some lobbying on this, and we did pretty well, I think, in trying to get this more employer friendly and more consistent with our goal to have this workplace free from harassment, free from hazards. And there's a law already in place called Labor Law Section 201D. It's been around a long time. And it essentially said that if it's unlawful for an employer to take an adverse employment action against somebody because of their political or recreational activities outside of working hours, an individual's membership in a union, or an individual's legal use of consumable products, right? So it's always been illegal to discriminate against smokers, right? You can certainly prohibit smoking in the workplace, and you must actually, according to New York State's Clean Indoor Act, but you can't just have a blanket policy where you refuse to hire people who smoke tobacco. Tobacco is a legal consumable product, and it would be illegal to discriminate against that. Similarly with recreational activities. You know, my hobby is jumping out of airplanes, and you refuse to hire me because of that risk, that would be discrimination. That's a legal recreational activity. We saw a lot of cases regarding this, regarding political activities. As you know, we had a pretty divisive presidential election recently, and we had several individuals discriminated against because of their political affiliations or outside political activities. It's not, you can take action if the employee's behavior as it creates a material conflict of interest related to the employer's trade secrets, proprietary information, or other proprietary or business interest, but that bar is really high. For instance, if you're a healthcare organization and you want to refuse to hire anybody who's smoking tobacco, I still don't think, because you think it's bad for your image, right? If they're seen smoking outside, the grocery store or something, and I know that person, they work at that doctor's office, and you think that would be bad for the image, that's probably not going to pass this test. It's a really high bar. I'm telling you all this because with the eventual Cannabis or Marijuana Legalization Act, it was an amended Section 201D. It amended the definition of recreational activities and consumable products to include use of cannabis in accordance with state law. Prior to the beginning or after the conclusion of the employee's work hours and off of the employer's premises and without the use of the employer's equipment or other property. So we now know that cannabis used legally in New York State, over 21, right? If your use of cannabis in accordance with state law is now a legal recreational activity. It's now a legal consumable product. But it goes on to describe some other things. And I know there's a lot of print on this, and I hate this on slides. By the way, we're going to get everybody the slides at the end of this program. That says we can take adverse employment action against people using cannabis if, number one, our actions are required by state or federal statute, right? If we have drivers who have to have a zero tolerance for the presence of cannabis metabolites in their system, we can continue to do that. And if they fail that test, we can take an adverse employment action against them. The two is the new and interesting one. We can take an adverse employment action if the employee is impaired by the use of cannabis, meaning the employee manifests specific articulable symptoms while working that decrease or lessen the employee's performance of the duties or tasks of the employee's job position, or such specific articulable symptoms interfere with our ability to maintain a safe workplace. We'll talk more about this in a second. And then the third bullet is if it would require us to commit any act that would put our violate federal law or jeopardize our federal funding. So we can take adverse employment action if the federal government requires it. So what are specific articulable symptoms? And what's important here is we have to observe these specific articulable symptoms. And not only that, if those symptoms are present, we still have to show that it decreases or lessens the employee's performance of duties or tasks of their job position. One could argue that lobbyists can work impaired. We've seen cocktail parties where that's evident. So just observing certain behaviors like red eyes, slurred speech might not lessen the employee's ability to do their job. Both of these have to be present before an employer can take adverse employment action. Some examples, one of the things we did as part of lobbying for this was let's include in the law a definition of specific articulable symptoms. Let's give them some examples because that's a tough phrase that we in HR aren't familiar with. So let's put things out there. I gave them this list. They said, yep, this is an excellent list. It's exactly what we're talking about. But no, we're not going to put it in the statute because we think it's too limiting. So as an employer, if you see these symptoms, we will now have observed specific articulable symptoms: impaired speech, physical dexterity, agility, coordination, demeanor, irrational or unusual behavior, negligence or carelessness in the operation of equipment or machinery, disregard for the safety of the employer or others, involvement in any accident that results in serious damage to equipment or property, disruption of the production or manufacturing process, or carelessness that results in an injury to the employee or among others. Now, this is actually from the Illinois cannabis law. I didn't make this up. We pulled it from there and tried to get them to insert it in New York State, and they wouldn't. But this is what's important. So now we see the symptoms: impaired speech. Maybe they're acting a little goofy, right? And they're violating safety rules. They know they're supposed to wear ear protection and eye protection when they do this, and they're not. If these two things can be present, then we can take adverse employment action. We could take adverse employment action against this individual. But that's going to be important that those are both present. What about drug testing? I changed this slide a couple days ago in response to a conversation I had with the Department of Labor. The Department of Labor is going to be putting out FAQs for employers regarding cannabis in the workplace. These are them. They're top secret and not available to anybody. But we had the ability to give some input as to what these FAQs should look like. One of the things that's clear in the statute is that pre-employment, reasonable suspicion, random, and post-accident testing is not specifically restricted under the new statute, right? There's nothing in the statute that says an employer is prohibited from doing drug testing. However, one of the things we have to be aware of is that cannabis metabolites, if someone uses cannabis on a Friday and you have a drug test on a Monday, it's likely that metabolites will remain in their system. They're detectable for up to 30 days. That does not designate impairment. Now, the presence of metabolites will cause them to fail a DOT test mandated by the federal government. But if they're not subject to that, then we cannot take adverse employment action because we can't demonstrate impairment. Testing for active ingredients of THC could demonstrate impairment, though we don't really have the science on this yet. This legalization movement is ahead of the technology, right? For alcohol, we have a test. We've all settled on a number, 0.08, as being a level of impairment. Employers can take action because we know what these numbers mean. There's no such test for cannabis. Colorado uses 0.5 milligrams per liter. Ohio uses a different standard. There's no agreement yet, plus there's no simple testing system, right? If we could have a breathalyzer you can get on Amazon for $20 that employees could use to determine alcohol on their breath and the level of impairment, there is no such tool right now for cannabis. But it's clear that testing for THC is the future of drug testing regarding cannabis. But a positive test is not enough to take adverse employment action. It could be used to confirm your observation or documentation of impairment. That's the question. So one of the FAQs proposed by the Department of Labor says, can an employer test for cannabis? Their answer is no. Can an employer drug test an employee if federal law allows for drug testing? No. It goes on to explain that unless you can do so pursuant to 201D4A. However, what the department has explained to me is that we clearly cannot take adverse employment action unless we see specific articulable symptoms while working that decrease or lessen the employee's performance of their duties or tasks. If we don't see that, if we don't observe those, then what would testing add to the decision-making process? So what if they test positive for the presence of THC or metabolites? They're not exhibiting these articulable symptoms that decrease their performance on the job. So in the view of the Department of Labor, is I think it's, now we disagreed on this when we had this conversation. I think employers should be able to retain the right to drug test. I think even if someone tests positive and can do their job, they can still fall down the stairs at the end of their shift, and an employer would be liable and obligated that under workers' comp or some other liability. Now, the Department of Labor, I think, disagrees. And I think what we'll see in the final Q&A, which, by the way, Q&A from the Department of Labor serves as guidance, which almost carries the weight of law, though not specifically, will say that there's no value to testing for cannabis. And there's already some other restrictions. Pre-employment testing for cannabis is prohibited in New York City. So if you have employers in New York City, you cannot pre-test pre-employment for marijuana, and really for anybody. What's the purpose of testing for cannabis metabolites pre-employment if we don't see any evidence of impairment? So pre-employment testing for cannabis has probably gone away, at least until the technology catches up and we have some simple device to do that. Reasonable suspicion and random testing, if you have programs like that in the workplace, perhaps they could survive, though I don't think so without the presence of these articulable symptoms. And we're waiting for the DOL to tell us that in guidance. Post-accident testing, we could say that that would reveal that an individual was impaired and therefore had these articulable symptoms, but the Department of Labor kind of disagrees. And if you remember, OSHA, back under the Obama administration, said that post-accident, a policy that required post-accident testing for everybody involved in an accident would have a chilling effect on those reporting accidents, right? If I'm on a work site and I'm walking along and Bob drops a 2x4 on my head and I'm injured, I'm not likely to report that if I know I'm impaired. If I'm subject to a drug test in an hour, I may not even report that accident because I used on the way to work. The Biden or the Trump administration reversed that, but I would assume that soon the Biden administration will reimpose that. So already our ability to test for cannabis is severely restricted. And I know we have many large employers who are giving up on testing for cannabis. And I think when the Q&A comes out from the Department of Labor in the form of guidance, we're going to see even fewer employers test for cannabis, which means we're all going to have to be, to a certain degree, drug recognition experts. We're all going to have to make sure that we're able to identify those conditions. So what do we need to do? We may need multiple policies, recreation and medical marijuana. If you have people under both of those, you might have to have multiple policies based on job title, truck drivers versus office personnel. Make sure you prohibit use consistent with 201D. I think it's important we explicitly state you can't come to work impaired. And I would keep the use off of our work location, any place we lease, any other any other building or anything we're responsible for. Make sure they can't use it during work hours and company vehicles, using machineries, et cetera. And testing, let's wait for the DOL guidance and see what they allow us to do. Supervisors are going to have to be trained. As you know, they're the eyes and ears of the organization. They're going to have to be trained to observe and document evidence of impairment and the degree to which it reduces their ability to do their job. We're going to have to look at job descriptions and maybe identify those tasks that could be impacted by impairment. And of course, document everything, document every interaction with an employee who we think is potentially impaired. The next major thing that's going on is the HEROES Act. As you know, the Health and Essential Rights Act was passed and signed into law. It requires businesses to do a couple of things. One, adopt an industry-specific airborne infectious disease plan. It's developed by the DOL and the DOH. We'll talk about that in a second. And two, workplace safety committees. Employers with at least 10 employees shall permit employees to establish joint labor management workplace safety committees. So what do we have to do now? What are the dates surrounding the HERO Act? The Airborne Infectious Disease Exposure Prevention Standard is the rule that comes from the Department of Labor that tells us what we have to do. They released those on July 6th of 2021. They gave out some industry-specific standards and some templates we can use to be compliant. We have to adopt the plan by August 5th. Now, what does adopt mean? It means how you would adopt any other policy. You don't need to go get a board resolution or any other formal activity to result in adoption. You just need to do what you do with any other policy. The way that works is I adopted our policy here and posted on the bulletin board, boom, adopted. We have until September 4th, next week, to communicate to employees that the plan exists, where they can find it, and who's responsible for updating the plan. They need to know that information. The DOL is not going to come around and say, where's your plan? You don't have to submit this to the DOL. But if they're in your building for something else, for a wage and hour audit or for a workers' comp audit, they might ask an employee, hey, your HERO Act plan, your airborne infectious disease plan, where is it? Who's responsible for updating it? Where can I find it? Make sure they know that. You have until September 4th to do that. Now, the DOL's guidance doesn't mention employees handbook, but the statute itself says explicitly that if you have an employee handbook, you need to mention it in the employee handbook. I'll have a sample slide here with some sample language for you to do that. Workplace safety committees are effective November 1st of 2021, so we have some time for that. Let's not worry about the safety committees now. So what does the plan have to do? It's going to cover every employee and independent contractor, anybody who works for staffing agencies. It's the workplace, right? OSHA requires us to have a workplace free from hazards. So if you have people in your workplace, in your office, on your job site, you're responsible for their safety, right? And this is the same as that. It's going to cover every work site over which we exercise control, company vehicles, employee housing, things like that, cafeterias. We exercise control over that. We're responsible for making sure that place is safe. We're not responsible, say we're a home health agency. We send home health aides into private homes of individuals. We're not responsible for that private home to be compliant with the provisions of the HERO Act once they're implemented. And it's going to cover all the stuff you know, right? Health screenings, face coverings, PPE, hand hygiene stations, et cetera. All the things we've been doing for the last 18 months are in there. There are fines and penalties for not doing this, including injunctive relief. There is a cure period where an employee can go to sue you if you fail to respond to a complaint. They can go to the Department of Labor and file a complaint, only if they give you 30 days to cure the problem. So if an employee comes to you after the plan is implemented and you do nothing about it, after 30 days, they can go to an agency and complain about your behavior. So on July 6th, the DOL at this website, dol.newyork.gov/New York HERO Act, put out a couple of things. The prevention standard, which is kind of like the rule. Think OSHA, right? OSHA puts out a standard. Here's the law. Then they gave us a model generic infectious disease exposure prevention plan. And then they gave us 11 industry-specific templates. You need to go through and adopt one of these plans, put it in place, and communicate it to employees by September 4th. Model plan uses OSHA language, which we're glad to. It talks about engineering controls, administrative controls, personal protective equipment. It applies to employers with work sites in New York State. Only an airborne infectious disease designated by the commissioner as highly contagious communicable disease that presents a serious risk of harm to the public counts. There is no such designation in effect today. I'm trying to see if the governor just did that, and I can't see that she did. It's possible that the HERO Act is implemented in the next few weeks when the Commissioner of Health says we have a highly contagious communicable disease. It's kind of weird that it's not in effect now, right? Because we have COVID, but right now there's no designation of an airborne infectious disease. So this plan you adopt, you're going to adopt this plan, you're going to put it in a binder, you're going to tell employees about it, you're going to put it on the shelf, and you're going to wait for the big announcement from the Commissioner of Health that it's in effect. Does not apply to independent contractors, or I'm sorry, employees of the state or any political subdivision. So if you're a municipality, it doesn't apply to you. Doesn't apply to any seasonal or endemic infectious disease or agents such as the regular flu. That's good. Again, the commissioner has to designate it as a risk to public harm. Does not apply to any employee who's already covered by some other law. And as you know, OSHA put out an emergency temporary standard for healthcare workers on June 21st. Those employees are covered by the OSHA emergency temporary standard, not by the HERO Act. However, there are a lot of overlaps between the OSHA emergency temporary standard, that's what ETS is, and the plan. If you have 10 or more employees, you have to have a written plan. So if you're a healthcare provider, you have to have your OSHA plan and you have to have a HERO Act plan. You could, if you're astute enough, you can make that into one plan. For everyone else, it requires we have a plan. If you have an alternative plan, if you don't want to use the templates that the DOL gave us, that's fine. You just have to make sure there's meaningful employee participation in creating your new plan. I would use the templates and wait for the DOL to designate an emergency. It talks about the employer shall consider and incorporate exposure controls. There's no new mandates on you right now other than doing the plan and communicating the plan. You have to review and update when necessary, make it available upon request to whoever wants it. You have to do a verbal review for employees. So I would send out an email to everybody saying, I would any other policy, you know, look, this is our HERO Act plan. This is where you can find it. This is who's responsible for it. It's activated upon designation by the Commissioner of Health. So when that announcement comes down, we take the plan off the shelf and we do what the Commissioner of Health tells us to do. Okay, and someone has to be responsible for the plan. Here's some sample handbook language you can use. It just says that we've adopted a plan that's pursuant to the law. It's to protect you. If it's activated, you'll know what you have to do, and here's responsible for updating. Again, it talks about the normal things we have to do, health screenings, face coverings, physical distancing, all the stuff we're used to. But whenever the disease comes out, there's going to be specifics from the Commissioner of Health on what we need to do. So look for that. You can't retaliate against people for exercising their rights under the plan, or for reporting violations, reporting concerns, refusing to work. An employee who refuses to work, an employee who thinks it's unsafe to work, must first come to you and say that. Let you know that they believe it's unsafe to work. You have to address that concern. If you don't address that concern, they can refuse to work and not be penalized by you. That already exists under OSHA. That's been the law for a long time in most cases under OSHA. You should know that. If there's a real legitimate risk, an employee who has a reasonable belief that they could be harmed by continuing to work, they can refuse to work. And there's a weird thing in here, record retention for 2 years. Once the plan is designated, if an employee expresses a concern to you, say they send you an email, I'm worried about working in this area because of the ventilation system, you have to retain those emails for 2 years. Nothing prior to this. Don't worry about all the COVID stuff we've been doing for months now. Only when the plan is activated by the Commissioner of Health. The next concerning part will be workplace safety committees. We're waiting for regulations from the Department of Labor on what all this means because there's a lot of serious questions. It says employers with at least 10 employees shall permit employees to establish a joint workplace safety committee. 2/3 of the committee must be made up of non-supervisory employees selected by and from non-supervisory employees without the interference of the employer and who serves on the committee. How's that going to happen, right? We got 25 employees, let's say. 2 knuckleheads come to me and say they want to be my safety committee, and it's the last 2 people on earth you want on that committee. And you say, what are you, crazy? I'm not having you guys be on my committee. It's entirely possible you've retaliated against these people under the HERO Act and under the National Labor Relations Act, which protects employees who are engaged in protected concerted activity and workplace issues. We need guidance from the DOL on this. They tell us it's coming. They've just been very busy. We have until November 1st on this, but I think we'll see some Q&A or some emergency temporary rule from the DOL on this. We'll get that before everyone else, and we'll do what we can to impact those. The committee has broad authority and powers. They can raise health and safety concerns to the employer, review the adoption of any policy in the workplace regarding employee safety. We want that limited, right? We want that limited to just airborne infectious disease. If we decide to go from an 8-hour day to a 10-hour day, does that impact employee safety? And does this committee have to review this? Participate in on-site visit by any government entity, they can already do that. Review any report filed by the employer related to health and safety. We don't want that. OSHA, if you're one of those industries covered by an OSHA 300 log, you know there's personal medical information on those OSHA 300s. And that's why we only post the summary. The committee shouldn't have access to that. We'll work with the DOL to stop that. They can regularly schedule a meeting at least once a quarter, not to exceed 2 hours. And they can attend training without loss of pay on the role and function of the worker safety committee up to 4 hours. We don't know if that's once a year training or once a lifetime training. We're waiting again for guidance from the DOL. So don't worry too much about the workplace safety committees yet, because there's a lot more information coming from that. Stephanie will probably want me to do a webinar for you on that when those rules come about. So look for more information on those in the near future. Focus now on getting your plan up in place and running and communicated to employees. Okay. So again, what's next regarding the HERO Act? We'll see regulations from the DOL, I'm sure, on this. And let's make sure we get something out to our employees by Labor Day, right? Let's get an email out to them or something. We got to let them know the plan's out there. Don't fall down on that requirement, because that's an easy one to do. So several bills passed both houses, and we're waiting to see what the resolution of those will be. One, add siblings to the definition of family for the purpose of paid family leave. Passed both houses. We're waiting for a governor to sign that. I imagine she may sign that one. Keep an eye out for that. Allows employees to petition for participation in shared work program. If you use that during the COVID pandemic, you know that's a way to have employees work fewer hours, get partial unemployment benefits. This would allow employees to petition you for that. It doesn't say you have to agree to it, but they can petition you instead of doing a layoff. Another bill would require employers to provide a notice regarding any electronic monitoring you're doing of them. If you're monitoring emails, you would have to have an annual notice posted to employees regarding that. Wage theft, a big one, will make contractors in the construction industry responsible for wage theft of subcontractors. We're actively urging a veto of that bill. We're actually vetoing most of these bills, but that is a big one if you're in the construction industry. Another one would prohibit discrimination or coercion or threats by employers based on an immigration status. I'd argue that's already illegal. You can't do that based on national origin. More bills that pass both houses. Strengthens protections for whistleblowers, people who report unsafe working conditions, and would require a poster for those specifically who work in healthcare. We'll watch that. You might remember the Secure Choice Pension Plan that the state passed a few years ago. It's not up and running yet. Again, supposed to be by now, but they've dropped the ball on this. This is a 401k plan managed by the state of New York for those employers who don't have the ability to put one in place on their own. This would require enrollment in the Secure Choice Pension Plan for all employees, and employers would have to manage an opt-out. So whereas now you don't have to do anything, this would require all employers to be aware that on the date of hire, if you don't want to be in the Secure Choice Plan, you have to opt out. That will be a new administrative burden on employers. We're actively urging a veto on that. There's a 1-year claim for widows of or dependents of workers who died of cancer caused by exposure to diesel exhaust. This is sort of you could go back 50 years and have employees claim that their loved ones died from cancer as a result of exposure to diesel exhaust. They could file a workers' comp claim. This would have a significant impact on the comp system that we all pay for, meaning employers. It would include independent contractors and new hiring reporting. As you know, we have to report everybody who's a new hire to newyorknewhire.com. This would make us do the same for independent contractors. That passed both houses. We're waiting. Things that didn't pass that we're watching, there are some bad workers' comp bills to make, for instance, COVID a presumption of that it happened at work. That would add $30 billion to the cost of our $8 billion workers' comp system, already the most costly in the nation. And again, employers pay for that. Equal pay disclosures with respect to state contracts, like an EEO-1 form for state contractors. An employee lien, we've talked about this before. It passed both houses. It was vetoed by the governor previously. It didn't pass this time, but will come back. That means if an employee claims you didn't calculate their overtime correctly, they could put a lien on your personal property if you're the owner of the company or an agent of the company, like the human resource director. We have Carlos law, which increases criminal penalties for supervisors who are supervising an area where an employee is injured or dies. Sealing of convictions didn't pass, though they're coming back this week, I think, to extend the eviction moratorium. The legislature's coming back. It's likely that they will do something regarding expunging records. The Empire Act gives third parties the ability to take enforcement activity on behalf of the Department of Labor. Unemployment insurance, we owe $13 billion to the federal government for UI claims. We're going to be paying for this a long time. This could be the most significant barrier to recover in New York State. Your UI costs per employee are going to go up significantly. Return to Albany, yep, looks like they're going to come back to extend the eviction moratorium. They might be doing more this fall. We expect the paid family leave, spelling error, PFL contribution rates to be coming out this week for 2022, right? When an employee has to contribute, we'll get the new state's average weekly wage for the purpose of coming up with the new maximum benefit. And then the 2022 minimum wage increase for upstate New York. It's $12.50 now. What's it going to be next year? It's based on an evaluation of the upstate economy. We'll know that October 1st. Could jump right up to $15 an hour, or could pick some number in between $12.50 and $15. We don't know, but we're waiting to see. We're trying to influence that. We don't want a jump right to $15 an hour. We'd like some middle ground. Let's go up to 70 cents like we've been going up. Worst case, split the difference of the $1.25. We'll see what happens. And that's it. I barely got it in under the buzzer, but I will take as many questions and stay as long as anybody wants me to stay on this.
Thanks, Frank. We do have a couple questions that have come in. Just a reminder, if you still have questions that haven't been submitted, just toss them in the Q&A and we'll get to as many as we can. So the first question we have is, we're seeing more interest from employers to mandate COVID vaccines for employers or provide a health insurance premium differential for those who are vaccinated or unvaccinated. Are you also hearing the same? Are there any concerns we should be aware of from the HR perspective?
Yeah, right. With the Pfizer getting full approval from the FDA, we're going to see more and more employers comfortable in mandating vaccines as a condition of employment. The issue is the other ones haven't been approved fully. So what if I got a Moderna vaccine and it hasn't yet received full FDA approval? Where do I fall in that? What if I only had one shot of the Pfizer? I'm not fully vaccinated. Are you going to make me take a vaccine now, or would they even give me one now? I think what I'm getting to is there's a lot of questions, a lot of risk for mandating vaccines. There are religious and disability objections that people could have. The booster, for example, is coming down the pike, right? That has not been approved yet by the FDA. Are you going to throw in the booster as a requirement to be considered fully vaccinated? Tons of questions, a lot of risk for employers. At this point, I think we're still in the realm of strongly suggesting and recommending vaccination. And then we have workforce shortages, right? We have a new mandate in New York State that all healthcare hospitals have to have mandated vaccines. They're already short-staffed and having trouble recruit people. What if they lose even 10% of their workforce as a result of this mandate? It could pose significant challenges. So think long and hard before you mandate vaccines for your employees. There are significant risks.
Sure, thanks. You mentioned there's no expiration on the COVID paid sick leave through New York State. Can you just confirm that is regardless of vaccination status?
Yeah, the law is silent on vaccination status. So we're seeing a lot of this. I'm an unvaccinated individual. I went to a party on Friday. Saturday, someone texted me, they tested positive. What do I do? Mm-hmm. There's no exception based on vaccination status at this point. What do I do is, well, you're not a contact tracer. You're an employee. You're not a health department. So I can't really determine what your status is just based on what you're telling me. Go get a test. Based on the test results, we'll determine whether you're eligible for COVID leave protections or not.
Thank you. If an employer requires that an unvaccinated employee be tested weekly due to their status, is the employer responsible to pay for that test?
Yeah, the law's silent on that, right? There's no law that talks about who has to pay for that. You could require employees to bear the cost of that. My only concern, the only thing I think would be applicable is we can't really require anything as a condition of employment that would reduce their pay below minimum wage, right? So if you require people to maintain and clean their own uniforms and the cost of doing that results in less than minimum wage, that's a violation of the minimum wage law. So you'd have to, how much does a test cost? How often are they doing it? How much should they make? Just be aware of that. But the law is silent. You can mandate that employees pay out of a sense of fairness. I think most employers are picking up the cost of that.
Okay. If an employer chooses to keep an employee home in this, because for whatever reason, but they can work remote, you're not required to pay them still, correct?
Correct. They're working. Yeah.
Okay. You mentioned a drug Q&A. Do you know when this may be available?
Yeah, the DOL is going to put out a Q&A on cannabis for employers. They didn't know when. They said they would let me know in advance. So as soon as I get word, I'll broadcast it out there so everybody can look for it. Okay. But we don't know.
Okay. To the Workplace Safety Committee, what if no one signs up for the committee? This company is a nonprofit legal service, so they don't normally have a safety committee.
Yeah, if no one approaches you to establish a committee, you don't have to proactively form one. This is something employees have to want to do on their own.
Okay. Any update on minimum exempt salary wage?
Well, the minimum wage, the minimum salary level for exempt employees in New York is 75 times the minimum wage. So when the minimum wage changes, the minimum salary levels change. By the way, that's nowhere in the law either. That's just a made-up number from the Department of Labor. So when the New York State upstate New York wage changes, the minimum salary level for exempt and administrative exemptions will change also.
Okay, and then my last question here, someone says, I heard from the governor maybe requiring sexual harassment prevention training for employees in New York to be completed as classroom training only. Do you know any additional information about this, or is this in the works?
Yeah, no, I heard that the governor say that too. Our interpretation of it is, and I immediately went to the transcript because we always get the transcripts. Our impression is she's talking about state workers. That it's for state employees who would have to do it live training as opposed to interactive online training. The training that's applicable to the rest of us is described in statute, and it clearly doesn't say live is required. So they would have to change the law to make it live for New York employers. So we think it's only for state workers.
Excellent. We were wondering the same. So
yep.
Thank you. That wraps up our questions for today.
All right.
Thank you, everyone, for joining us today for Frank's webinar. And Frank, as always, thank you for sharing your insight and expertise. If you have any additional questions or would like to connect directly with the Walsh Duffield team, please feel free to reach out to us. We are available to assist with any of your risk management, employee benefits, or well-being needs. Again, thank you for participating in our summer school webinar series. If you are interested in the playback of any of our previous webinars, visit walshduffield.com/summer school. Have a wonderful rest of your day, and thanks again, Frank.